having been subjected to non-payment of their furniture allowance. C, the sum of 10 million naira being cost of litigation. D, 10% interest on the judgment sum from the date of judgment until the entire sum is paid to the claimants. Upon being served with the originating court processes, the defendant filed their statement of defense on the 11th day of March 2022, which was deemed properly filed on the 2nd day of June 2022 by the leave of this court. In attempt to prove their case, the claimants called one witness, the first claimant, who testified as CW1. CW1, after identifying his witness statement on oath, adopted same as his evidence in proof of the claim before the court. Documents were tendered in evidence through CW1, and they were marked as exhibit CW1A to CW1T. CW1, under cross-examination, stated that he is a member of PDP. He did not decamp to APC. It is easy to contact because they are fighting the same cause. They have their contacts. The matter referred to is suit number NICN/CA/47/2018, that he stated in paragraph 3 of the statement on oath that he has contacts of 797 claimants, which include the 5 claimants in NICN/CA/47/2018. This court can strike out the 5 names. The 5 claimants have gotten judgment in their favor. The defendant on their part also called one Leo Egede, the Director Administration Ministry of Local Government, Cross River State, who testified as DW1. DW1, under cross-examination, stated that between 2014 to 2016, some persons served in the local governments as political office holders. The ministry has list of chairmen and political appointees. He is aware they are entitled to furniture and severance allowances. It is not within his schedule to compile names and entitlements. He may not know the names, but he knows they are legal advisors across the local government's council. He is aware furniture allowance has not been paid, but severance allowance has been paid. The submissions of counsel for the defendants. Amajama Energy Esquire, the Director of Civil Litigation, Ministry of Justice, appearing for the defendants, submitted a single issue for determination, to it whether the claimant have proved their case to be entitled to reliefs being sought. In arguing the sole issue, the learned Director of Civil Litigation submitted that the burden of proof lies on any party in an action who desires a favorable judgment of the court to be given in his favor, and proof of facts asserted. He must prove that the facts asserted exist. In support of this submission, counsel refers to the case of Parumoti versus Agbeke, reported in 1991, 5 Nigerian Ukulolo Report, Part 189, page 1. Counsel continues his submission that the burden of proof of existence or non-existence of fact lies on the party against whom the judgment of the court will be given if no evidence were produced to support this submission. To support this submission, reliance was placed on the cases of Womiloju versus Amibere, reported in 2010, All Federation Ukulolo Report, Part 529, page 1002. He also referred to the case of Isiobe and another versus Adelakun, citations supplied. According to learned director, the claimants have failed to establish the existence of material facts in this case to grant them a favorable judgment. They failed to approach the local government councils where they served as elected officials and appointed officials for the payment of their furniture allowance. By virtue of the Constitution of the Federal Republic of Nigeria, 1999, as amended, precisely the provisions of Schedule 2, Second Schedule, the local government council are independently the third tier of government. with its own structure and administrations, and therefore cannot be appendage to first and second defendant in this action. It is also the submissions of counsel for that the claimants have also failed to serve any demand notice for their furniture allowance on the local government council, who are the direct beneficiary of their services during the tenure they serve. Neither did the claimant join the 18 local government council in this case. According to council, the failure to join local government councils and the failure to submit demand notice on them, this is fatal to their case, and this case is bound to fail. On the claimant's claim for an order in the sum of 500 million compensation and an order in the sum of 10 million naira cost of litigation, counsel submitted that the claimant have failed to place any material evidence before the Honorable Court in support of their claim to prove the claim they are making. They also failed to lead evidence of what they have suffered to evoke the sympathy of the court to award the whooping 500 million naira as compensation. On the payment of cost of litigation, counsel submitted that a claim for litigation cost is a claim for special damages, which by law must be specifically proved. In support of this contention, reliance was placed on the case of Lone Star Drilling Nigeria Limited versus New Genesis Executive Securities. He also relied in Naude versus Simon. The landed director of civil litigation insisted that the claimant did not place anything before the court in the course of proving their case. Not even the receipt of payment of litigation fees was tendered before the court. In concluding his submission, the landed director of civil litigation submitted that with the gross failure of the claimants to prove their case on the preponderance of evidence and the failure to tilt the balance of probability to weigh on their side, the claimants are not entitled to favorable judgment in this case. Counsel asked the court to refuse the claim and dismiss the case. The submissions of the claimants in their final written address, as submitted by the counsel, formulated a single issue for determination, to which whether the claimants have placed sufficient evidence before the court in proof of their case to be granted a favorable judgment. In arguing the sole issue, counsel refers to the provisions of Section 2 of this Cross River State Political Office Public and Judicial Office Holder Remuneration Package Law Number 12 of 2007, which provide for payment of furniture allowance among other benefits to the claimant. According to counsel, in the course of their service to the defendants, the claimants were paid by the second defendant, who is in absolute control of resources of the 18 local government council in the state through the instrumentality of the account called Jack account, domiciled in the commercial bank. Counsel continued his submission that the claimant have earlier in 2017 been paid their severance allowances by the second defendant. The local government councils are not and have not been responsible for the payment of both civil and public servants. The duty have always rested on the second defendant. Counsel submitted that this court had earlier had and determined two cases bordering on implementation of Law Number 12 of 2007 as it affects severance allowance, which is one of the benefits accruable to the public officers serving under second defendant. In suit number NICN/CA/14/2018, the defendants opted to negotiate and parties filed terms of settlement, which became the judgment of this court. The filing of the terms of settlement presupposes that the defendant knows that the duty lies on them to pay the allowances of the defendant in that suit. In that suit, the second and third defendant are dependent in this action. Counsel further submitted that this honorable court also decided suit number NICN/CA/47/2018 in favor of the claimants. Counsel placed a reliance on the decision of this court in these cases. Counsel submitted that contrary to the amendment contained in the dependent statement of defense, their lone witness, who is the director of administration in the Ministry of Local Government, the ministry under which is the second dependent, which control all the government in the, all the governments, all the local governments in the state, admits that they have the list of all the claimants who are entitled to the payment of furniture allowance and they have no to be paid. It is submitted that the unwillingness to pay the claimants their furniture allowance, even though it was approved by the governor, motivated the action to seek their rights. In compliance with the provisions of Order 13, Rule 11 of the rules of this honorable court, the claimants, who are 797, insisted this institute initiated a representative action. They have exhibited their signed authorization to that effect. It is submitted that it is the duty of second dependent to keep to the provisions contained in Section 2 of the Law Number 12 of 2007 and pay the furniture allowances of the claimant herein. To support this submission, counsel relied on the decision of this court in Ore Division in the case of Prince Chidebere Ogoke and others versus Iheme Umbano Local Government, suit number NICN stroke OW stroke 32 stroke 2016, delivered on the 15th day of May 2019. In concluding his submissions, counsel urged the court to exercise its discretion in favor of the claimants by granting the relief sought. The decision of this court. I have carefully considered the processes filed, the evidence laid by the parties, and the written and oral submissions of counsel for the parties. The claimants have stated that there are 797 former local government political office holders out of 802 who serve in the 18 local government areas of Cross River State from 2015 to 2016. The claimants have averred that they are former chairmen, councillors, supervisors, special advisors, legal advisors, special assistants, protocols, press secretaries, and personal assistants in all the local government councils of Cross River State. According to the claimants, since the completion of their tenure in 2016, they have not been paid their furniture allowance till date. In spite of the approval to pay same by the governor of Cross River State, the approval was sequel to submissions of committee report on outstanding pension gratuities and allowances by the members by the 13-member committee. The claimant stated that the total sum of furniture allowance of all the 797 local government political office holders for 2015-2016 in the 18 local government councils of Cross River State amount to the sum of 1,045,808,681 naira. It was stated that despite oral and written appeals, the demand for payment of their furniture allowance to Governor of Cross River State and copying to the Commissioner for Local Government, as well as the Attorney General and Commissioner of Justice and the State Chairman of the People's Democratic Party, the defendants have refused or neglected to pay and failed to pay them their furniture allowance till date, and they are currently passing through agonizing financial hardship with their families due to the continued of non-payment of their furniture allowance. The defendants on their part have stated that while some of the claimants, like the chairman, vice chairman, and councillors were elected into offices of the different 18 local government councils, constituents, the other claimants, like the secretaries, special and personal assistants, etc., were appointed by the elected officials to serve in the separate local government council. The claimants denied any approval given by the governor for payment of furniture allowances to the claimants. The defendants have stated that they are not indebted to the claimants, as they did not and never appointed the claimants into any political office between 2014 to 2016. The claimant suit is speculative and gamble. The claimants and the defendants each submitted loan issue for determination. A careful perusal of the issues formulated by each of the parties will show that they are talking of the same thing. They only differ in the way the wordings were couched. I believe a single issue will dispose of this case, to wit, whether the claimants have proved entitlement to any of the relief sought. Before proceeding to determine the loan issue for determination, I shall first and foremost consider certain very important preliminary issues arising from the evidence and submissions of counsel before the court. The first preliminary issue which worthy of consideration is the reliance by the counsel for the claimants on a number of unreported decisions of this court without supplying the court with the certified true copies of the said judgments. Order 45, Rule 3, Sub Rule 1 of the National Industrial Court of Nigeria Civil Procedure Rules 2017 provides that where any unreported judgment is relied upon, the certified true copy shall be submitted along with the written address. Rule 3, Sub Rule 2 of same order then provides that failure to comply with this may render the written address incompetent. In considering a similar issue, Her Ladyship Amina Auge JSC in Major General Kayode Oni retired and 4 others versus the Governor of Ekiti State and another reported in 2019, LPELR 46413 SC strongly put the law thus. I quote, "It is an elementary principle, very elementary, that the counsel who want the court to make use of authority cited in court must provide the name of parties there the case was decided and where the case is reported. Name of the law reports, their volume and page must be cited. But if the said case is unreported, counsel must provide the court with a certified true copy of the judgment sought to be relied upon. See the case of Chidoka and another versus First City Finance Company Limited, reported in 2013, 5 Nigerian Ukulele Report, part 1344, page 144. And Ugo Inagadi versus FRN, reported in 2018, LPELR 4390 SC. In this case, the appellant did not provide this court with copies of its judgment in Governor of Ekiti State versus Chief Judge Ojo and others, and Governor of Ekiti State and another versus Chief Femi Akinyemi and others. They merely quoted what the Court of Appeal said in those cases, and there is nothing to indicate what principles this court affirmed. In line with the National Industrial Court Rules 2017 and on the authority of Major General Kayode Oni Sufra, I shall discountenance all the unreported decisions cited by the claimants, given the fact that no certified true copy of any of the decisions were tendered before the court. The second preliminary issue to be considered and resolved is evidential value of exhibit CW1B to CW1S. I have taken a hard look at this exhibit. They are in form of table with columns showing purported names of Cross River State local government political office holders 2014 to 2016, position held, annual basic salary period served, furniture, severance, and remarks. One remarkable aspect of this exhibit is that they have they have no author. They were not signed and were not dated and addressed to anybody and addressed to nobody. In law, these documents are worthless. They do not command any evidential value in law. The law is right that document that has no signature or date is not capable of proof of any assertion. In the circumstances, I hereby discountenance Exhibit CW1B to CW1S. The law is well settled that documents which do not bear the signature of their makers should attract little or no weight. An unsigned document is lacking in value and is worthless. See the cases of Ojo versus Adeobi, Abia State versus Agaranya, SPDC Nigeria Limited versus Olarewaju, Omega Bank Nigeria PLC versus OBC Limited, Paro Bottling Company versus Osuji, Omega Pashehun versus Attorney General of the Federation, Jimadu versus Irosorobi Aro, Enemaku versus MS Company SA versus Enemaku, Aku Bioro versus Mobile Oil, Apga versus Almakura. All the citations have been supplied in the judgment. Coming to the main issue for determination, it is tried law that parties and the courts are bound by the reliefs claim in the action. Therefore, a case is put on the relief sought. A case is not fought outside the relief sought. Relief is the live wire of an action. Relief put in specific demanding language the course of action. Where there is no relief sought in an action, there is nothing for the court to grant. It is the bedrock of the entire action. The action can either stand or fall by relief sought. See the case of Otun versus Otun. See also Uzoduku versus Ezionu. See also Ehile versus Ikorodu local government. All the citations have been supplied. Going by the principles of law enunciated in the above cases, the reliefs being sought by the claimant will guide the determination of the claim before the court. In the claim before the court, there are 4 reliefs being sought. They are reliefs A to D. Relief A is for the sum of 1,045,809,681 naira, being furniture allowance for the 797 former local government political office holders from 2014 to 2015 in Cross River State. The relief is the main reliefs being claimed by the claimants, while the reliefs B, C, and D, which are on compensation, cost of litigation, and 10% interest, are ancillary claims which are dependent on the grant of relief A. For an employee to properly lay claim to payment of salary and other employment benefits from anybody or person, the employee must prove that he was employed by the employer on a stipulated salary and that he had worked for the period of claim. See the case of Honica Sawmill Nigeria Limited versus Hope, reported in 1992 for Nigerian Ukilolo Report, part 238. From the evidence adduced by the claimant in the course of trial of this case, there is nothing to establish that the claimants were employed or are employees of the defendant in this case. In their own evidence, the claimants only stated that they are former political office holders that served the 18 local government councils of Cross River State from 2014 to 2016. This assertion clearly shows that the claimants never served the defendant in this case in any capacity whatsoever. This goes to support the defense of the defendants to the effect that they never employed the claimants or appointed them to any post or position. There is no iota of evidence before the court to point to the fact of contractual relationship existing between the claimants and the defendant in this case. In this wise, I find and hold that the defendants, having not shown to have been the employers of the claimants, are not proper parties in this suit. Therefore, the claimants wrongly join the defendant in this suit as they are not employers of the claimant. The implication of this finding is that the dependent in this suit are not supposed to have been sued or joined in this case as parties. In the circumstances, they are not proper parties in this case, and their names must be struck out. And I hereby struck out the names of the defendants. With the striking out of the names of the defendants, there are no defendants to defend this case. Therefore, this case fails for lack of proper parties to defend. In the circumstances, the claimants fail to prove their case against anybody or any person. The counsel for the claimants have also argued in the final written address of the claimant that in the course of their service, the claimants were paid by the second defendant, who is in absolute control of resources of 18 local government council. I have perused the pleading of the claimant. There is no such abatement. Counsel should remember that he is not a party or a witness in this case. His duty does not extend to giving evidence. Counsel cannot, in the guise of final written address, give evidence in the final written address. The address of counsel cannot replace evidence. In the instant case, the failure of the claimants to plead that the second defendant paid their salaries or allowances during the period they served in the 18 local government councils of Cross River State could not be atoned through the written address of counsel. In any case, a bare statement of counsel in final written address can never be evidence. A counsel cannot use the opportunity of this final written address to adduce evidence from the bar. See the case of Obekfa versus COP. See the case of Niger Construction Limited versus Okubeni. See also Tahiru versus State. See also Sharing Cross ES Limited versus Umaru Adamu Enterprise Limited. See also Timothy versus the people of Lagos. All the citations of these cases have been supplied. The law remains that address of counsel, no matter how beautiful or brilliant and erudite, cannot take the place of evidence or record. An issue merely raised by counsel in his address cannot be part of evidence before the court and ought to be discountenanced. In the instant case, the submissions of counsel for the claimants that the second defendant did not pay the claimants during the period they served the 18 local government must be discountenanced because it was done in the final written address without the parties joining issues on same. See Dodo versus Solanke. See also Omishore versus Areboshola. See Andrew versus INEC. All citations have been supplied. My finding above is enough to dispose of this case. However, this court, being the court of first instance, has a duty to proceed to determine the merit of the case before the court. Relief A, as reproduced above, clearly shows that the claim being monetary in nature is a low claim for special damages, which by the case of 7-Up Bottling Company versus Augustus is to be specifically pleaded and particularized. It is to be noted that for claim of special damages to succeed, it must be specifically and specially pleaded and strictly proved. See also NNPC versus Clippo Nigeria Limited, stressing further on the need to strictly prove special damages. The apex court in the case of NECA Manufacturing Company Limited versus African Continental Bank Limited has this to say: where the claimant specifically alleges that he suffered special damages, he must purpose prove it. The method of proof is to lay before the court concrete evidence demonstrating in no uncertain terms, easily recognizable, so that the opposition party and the court will see and appreciate the nature of special damages suffered and being claimed. The tried position of the law, as restated in the above decision of the apex court, is that a claim for special damages being exceptional and specific in nature can succeed only upon concrete proof and not upon admission, either implied or express. Put differently, because special damages are exceptional and specific in nature, they will not succeed and will not be granted as a matter of course upon admission, express or otherwise, even where it is specifically pleaded as required by law. In the case at hand, the claimants are claiming payment of furniture allowance amounting to the sum of 1 billion, over 1 billion naira. But in the pleading, they fail to particularize the claim as there is no evidence to show what each of the claimant is entitled to as furniture allowance. By law, entitlement to specific damages must not only be specifically pleaded, it must also be strictly proved. Admission either on basis of default of pleading or on pleadings without evidence to show the claimant's entitlement is not enough to prove special damages. The success of a claim in special damages depend on the strict proof of what is claimed. Where the claimant failed to prove his claim of special damages, he cannot rely on the defendant's admission on pleading, and his case is bound to fail. It is to be noted that special damages are claims that the law does not presume or infer from the nature of act complained of. This is because they do not flow or follow in the ordinary course of events. Like in the case of general damages, they are special and exceptional in their character. Hence, they must be specially pleaded and strictly proved. See Onuibo versus Unwekeso. See also Ekena versus Nkpakara. See also Badmos versus Abegunde. See also Inka Nigeria Limited versus Adeboye. Citations supplied. Therefore, for a party making claim for special damages to succeed in an action for special damages, it must be strictly proved. The term strict proof means no more than that the evidence adduced must ventilate and vindicate the particulars pleaded. In the statement of claim, the evidence must indicatively particularize and exactly identify with clarity the abad losses with measurable exactitude. The required standard is not especially or exceptionally high to the extent of not being readily attainable. What is required is evidence which is apt and of such a magnitude that lend itself to ascertainable proclivity. That is amplified evidence necessary to conspicuously establish the pleading and computed amount being claimed. In any event, what determines strict proof depends largely on the given facts and peculiar circumstances of each case. Invariably, the burden in this regard is discharged when there is credible evidence that enhances proximate assessment or quantification of the alleged losses or damages. It is also necessary to point out that proof of entitlement is obtained by reference of instrument or document that grants the said entitlement. In the case at hand, the claimants have not provided any basis for quantification of the entitlement. The claim of the claimants being for special damage must be claimed specifically and proved strictly. The facts that it appears to be admitted does not relieve the party claiming it of requirement of proof and by compelling evidence. See NNPC versus Clipo Sufra. See also Mr. Ignatius Anyao and others versus Mr. Aloysius Uzuamaka and others. All items or loss must be specified by the claimant before they may be proved and recovery granted. In the case at hand, the defendant did not specify which each of the claimants is entitled to as his furniture allowance. See Mr. Christopher U. Nwaji versus Coastal Services Nigeria Limited. See also Energy Limited reported in 2004 LPELR 2106 SC. Furthermore, the claimant has a duty to give specific particulars of the special damages he is claiming. This is to enable the opposition party know what is to meet in the case. See Attorney General of Anambra State versus CN Onuase Logu Enterprises Limited. See also Marine Management Association Incorporated and another versus National Maritime Authority, reported in 2012 LPLR 206SC. In the case at hand, the claimants, in proof of their claim, relied on Exhibit CW1A letter to the governor of Cross River State appealing for payment of their furniture allowance. Exhibit CW1A being letter of demand cannot prove entitlement to claim for furniture allowance. In that respect, the law has always been that parties must succeed or fail on the strength of their case as presented before the court. It is a well-established principle of law that special damages claimed by a party must be strictly proved. See Dumes versus Oboli, see Agunwa versus Onwokupe. Wherever special damages are claimed, the party so claiming has an appeal tax of strict proof. In effect, the rule requires anyone asking for special damages to prove strictly that he suffered such special damages as he claimed. Thus, the claimant should establish his entitlement to that type of damages by credible evidence of such character as would suggest that he is indeed entitled to an award under that head. The general law of evidence as to prove by preponderance of evidence in civil cases operate in this. I'm sorry, sorry, my network went off. I will continue from where I stopped. The general law of evidence as to prove by preponderance in civil cases operate in discharging such burden of proof. In the instant case, the claimants fail to prove special damages. The failure to particularize and strictly prove special damages by qualitative and credible evidence renders the claim for special damages liable to be dismissed. The law is well settled that for a party to be awarded any reliefs by a court of law, that party must not only plead with particularity, but also prove by credible, convincing evidence that he is indeed entitled to the relief being sought. A court of law has no justification to grant a party that which he has not asked for. Court ought to not play the role of Father Christmas, which can go around granting the parties reliefs which they have not claimed. It is pertinent to stress that the claimant's claim fail to show what each of the claimants is entitled to as per item of claim. The claimants must fail since the claim is in the species of special damages, which must be specifically pleaded and strictly proved. This was not done by the claimants in the instant case. See NNPC by versus Kilipo. It held that special damages are never inferred from the nature of the act complained of, See also University of Ilorin Teaching Hospital versus Abegunde and others. See also Arab Contractors Limited and another versus Isaac. For the remaining 3 reliefs, B, C, and D, which are compensation in the sum of 500 million naira, cost of litigation 10 million, and 10% interest. As pointed out earlier, these reliefs are ancillary. They are dependent on the grant of Relief A. Having refused to grant Relief A means that the reliefs B, C, D also fails. These reliefs also fail and they are also refused. From my finding above, the claimants have woefully failed to discharge the onus of proof which rests on them and are therefore not entitled to the judgment in their paper. Before drawing curtain in this judgment, let me say that this case has raised the question of independence of the 3 tiers of government as provided for in the Constitution. By the Constitution, the 3 tiers of government, i.e. the federal, state, and local governments, are independent entities, each having powers to conduct its affairs without interference of the other, as the Constitution has limited the powers of each tier of government. Therefore, federal government has no power to make employment or appointment of personnel on behalf of the state government. Likewise, the state government does not have the power to make employment or appointment of personnel for the local government in each state. If such happens, it must be resisted. As such is without bias, as each of the tiers of the government is an independent entity of its own, having the right to recruit the personnel it wants to have to serve for it. In the case of Friday versus government of Ondo State, the Apex Court, while commenting on tiers of government, has this to say: by the provisions of the Constitution, the local government council is the 3rd tier of government in Nigeria's federal structure of government. No tier of government is a subset of another. Their relationship is defined by the Constitution and other laws. Each must respect this relationship and deal with each other only in accordance with the Constitution and other laws. This therefore means that the Cross River State government does not have the power to make employment for and on behalf of this 18 local government in the state. Each local government is an independent entity that has the power to recruit its own personnel, pay them the salaries they negotiated, and not that the state government shall employ and pay their salaries. If that happens, that is not in conformity with the law. From all I have been saying above, the claimants in this case fail to bring the relevant parties or the appropriate parties that are supposed to be sued before the court. Having been employees of the local government and serve the local government, it is only the local government that can pay their salaries, and it is only the local government that can pay their entitlement, and not any other person who has not employed them. In the final result, and for all the reasons I have given above, this suit is unmeritorious. Same is hereby dismissed. I make no order as to cost. You're welcome.
Okay.
Yes, Registrar, any other matter?
No, for today, my God.
Okay. Thank you very much, Council, and all those who have participated. We have come to the end of the virtual sitting. Administrator, you can end the sitting, please.
Thank you, my lord. What did he say?
Don't you see my colleagues? Who did the book I didn't make a Friday in 21st? I agree, come on.
Abịara ekwere meeting era okwere. Ndị obodo kwesịrị ịdị